Hello students, welcome to E-Pathshala. I am Dr. Shruti Bedi, Professor of Law from Punjab University, and will be speaking to you about the module on the due process of procedure established by law and the Constituent Assembly cogitations. Now, procedure established by law under Article 21 of the Indian Constitution was incorporated in the article after much debate and discussion about whether the right phrase to include in the Constitution would be the American concept of due process of law or the Indian concept as we have today, that is the procedure established by law. The procedure established by law and the due process of law, two debates or two concepts which were debated, were basically based on the concept as to the power of judicial review to be given to the Indian judiciary. Whether the judiciary should have the power of judicial review to sit in judgment over the decision of the legislature, which was elected by the will of the people and therefore reflected the desires and wishes of the people of this country, or whether it should be the legislature which would have the final word on this particular aspect of Article 21, whether a law could be declared to be ultra vires or unconstitutional because it was against the constitutional principles of the basic structure of the Indian Constitution, or in other words, whether the concept of basic structure had negated the rule of substantive procedure established by law. The main issue involved in the debate over due process of law, as given in the US Constitution, and procedure established by law as provided for in the Constitution of India, is whether the courts should have the right to strike down as ultra vires a law enacted or a constitutional amendment made by the legislature elected by people, and whether the power of judicial review vested in the judiciary should be allowed to override the basic function and powers of the legislatures to legislate. In other words, and in particular relation to India, whether the doctrine of basic structure propounded by the Supreme Court of India in the Keshav Nanda Bharati case in 1973 has negated the principle of procedure established by law given in the Constitution of India. In the following discussion, we attempt to review the debate in the Constituent Assembly of India in order to understand why the Constituent Assembly gave its preference for the procedure established by law, and what do the minds of the founding fathers imply for the situation emanating out of the basic structure doctrine given by the Supreme Court of India in 1973. The issue was keenly debated in the Constituent Assembly while discussing draft Articles 15 and 15A, Articles 21 and 22, because the drafting committee chose to override the recommendations of the Constituent Assembly's Advisory Council on Fundamental Rights. The matter was reopened again 9 months later with the introduction of the draft Article 15A by Dr. B.R. Ambedkar. In both the cases, the drafting committee succeeded in having its way with the members' objections and inserting the articles in the Constitution of India. The debate, rather the process of this debate, and the Constituent Assembly's decision on it went through 5 stages. The Constituent Assembly's Advisory Council on Fundamental Rights recommended the use of the phrase due process of law in the article meant to secure protection of life and personal liberty to be incorporated in the fundamental rights. The drafting committee changed it to procedure established by law in the draft Article 15. Most members of the Constituent Assembly taking part in the discussion on the draft Article 15 argued in favor of due process, as they felt that parliamentary power emanating from the procedure established by law could be misused on partisan grounds to curb personal liberty of individuals, both citizens and non-citizens. Dr. B.R. Ambedkar, in his reply to the debate, felt that it was a difficult choice and did not show any particular preference for either, leaving the choice to the members who eventually voted to retain procedure established by law as proposed by the drafting committee. The issue was virtually reopened 9 months later when Dr. Ambedkar introduced draft Article 15A, now Article 22, for discussion, which, taking account of sensibilities of the members of the Constituent Assembly, attempted greater safeguards for citizens by making two clauses of the CRPC constitutional, virtually taking them away from the Parliament's amending powers, as it were. This, he claimed, brought in the spirit of substantive due process in the functioning of the procedure established by law. Between 1 and 2 came Constituent Assembly's constitutional advisor B.N. Rao's understanding of the functioning of the US Constitution, where he thought that the Supreme Court has abused the substantive due process. Any doubts in his mind were removed after a discussion with Justice Frankfurter of the US Supreme Court, who pointed out to him that the matters of the American Constitution intended to use due process as a procedural safeguard only, but the US Supreme Court enlarged it into a substantive safeguard too. That, according to Frankfurter, made the judicial review undemocratic because the court could strike down the policies of the government even by taking the stand that they were substantively opposed to provisions of the Constitution. He was therefore for restricting judicial review to procedural grounds. According to Sirvai, by substituting for the words due process of law the expression except according to procedure established by law, the drafting committee did not make the American concept of due process more precise as a matter of drafting. The committee gave up the concept altogether. The finality in Sirvai's observation regarding the preference of the drafting committee for procedure established by law as against the American concept of due process, which was comprehensively rejected despite the strong tilt several members showed towards the concept, suggests the limitations of the doctrine of basic structure for the Constitution of India. Meaning and implication. Both of these concepts are linked to the evolution and eventual institutionalization of the doctrine of the rule of law as part of democratic theory, practice, and governance. Aside from overall importance of the Magna Carta in laying the foundation of civic and human rights, due process was among the first legal instruments to create the basis for fair trial of an accused both in procedure and in substance. The following two articles of the Magna Carta deserve attention in order to understand the primacy that the law of the land and lawful judgment of the peers acquired in delivering and ensuring justice in a democratic system. No man shall be arrested or imprisoned or seized or outlawed or exiled or in any way victimized, neither will he attack him or send anyone to attack him, except by the lawful judgment of his peers or by the law of the land. To no one will we sell, to no one will we refuse or delay right or justice. As pointed out by one of the members of the Constituent Assembly, the expression per legem terrora in the Magna Carta had come to mean without due process of law. Later, the Statute number 28 during the reign of Edward III read, "No man of what state or condition soever he be shall be put out of his lands or tenements, not taken, nor imprisoned, nor indicted, nor put to death, without he be brought to answer by due process of law." This was perhaps the earliest use of this expression, certainly earlier than its use in the Constitution of the United States of America. The idea of substantive due process was developed in the 18th and 19th century in the USA. The Bill of Rights and 10 amendments, particularly the 5th Amendment to the US Constitution that were passed as a single unit on 15th December 1979, and the 14th Amendment ratified in 1868, established that the idea of due process was substantive too. While proposing the Bill of Rights to the Congress, James Madison thus explained, "Magna Carta does not contain any one provision for the security of those rights, respecting which the people of America are most alarmed. Substantive due process has thus developed as a limitation on the power or authority of government legislative bodies to abridge any person's life, liberty, or property interests." The Constituent Assembly debate on Article 21. The debate on the draft Article 15 began with members expressing surprise that the drafting committee ignored the recommendation of the Constituent Assembly's Advisory Council on fundamental rights to incorporate due process of law in the article meant to secure protection of life and personal liberty in the section on fundamental rights and opted for procedure established by law. And of course, it prefixed personal to liberty, which, except for a few dissenting voices, was generally accepted. The debate that followed on the draft article was informed by the situation in the USA and concerned with effective judicial protection to personal liberty. It was felt that since Parliament, party politics as well as conventions and traditions governing them had yet to evolve in the country, partisanship was expected to be the guiding element of parliamentary politics. Naturally, most members of the Constituent Assembly who introduced amendments in the draft article to restore due process and took part in the debate were worried that procedure established by law would weaken the role of the judiciary in protecting personal liberty from an executive and a legislature that had not developed norms for governing a complex and diverse society such as India and could be capricious and impulsive under the existing Indian situation. Qazi Sayyid Karimuddin strongly urged that procedure established by law does not make the rights inalienable. Moreover, since institutions were yet to be developed, political parties were not fully developed, and discipline is unknown. It was advisable to have judicial protection. Supporting the amendment to substitute procedure established by law by without due process of law, H.V. Pataskar drew attention of the Constituent Assembly to the fact that the new democratic India will naturally have a party government, which was new in the Indian context, and we have instances which lead us to think that the party machine at work is likely to prescribe procedures which are going to lead to the nullification of the provision that we have made in the fundamental rights. Mehboob Ali Beg Shah Bahadur, for example, wanted except according to procedure established by law substituted with save in accordance with law, because the concept of procedure established by law was taken from Article 31 of the Japanese Constitution, which ensured life and liberty of persons within Japan's territory according to procedure established by law, without providing for the safeguard available against misuse of authority by the Japanese law enforcing agencies in subsequent Articles 32, 33, 34 and 35. He had no objection to the change made by the drafting committee, provided the provisions for the rest of the 4 articles from the Japanese Constitution were also incorporated to ensure the legal safeguards. In fact, by referring to the Japanese Constitution, he raised the issue of police powers of the state, which could be misused unless sufficient judicial protection had been guaranteed to fundamental rights. Pandit Thakur Das Bhargav objected to too much emphasis placed on procedure and making it sacrosanct in the process, weakening the substantive law. He said, though these words without due process of law, which were sought to be substituted for the words in the section, have not been defined anywhere, their meanings and implications should be understood fully. By using these without due process of law, we want that the courts may be authorized to go into the question of substantive law as well as procedural law. Due process to him took care of both procedural and substantive law and gave the people greater right to defend themselves against capriciousness of an emerging state. He strongly endorsed Mehboob Ali Beg Shah Bahadur's contention on the provisions of the Japanese Constitution. Other members also supported the due process against procedure established by law, such as Krishna Chandra Sharma and K.M. Munshi, also thought that it would provide a necessary judicial protection to personal liberty and fundamental rights against a strong state. They did not think that the functioning of the due process in the US Constitution had created such anomalies that it would lead to unexpected and unwarranted strengthening of the judiciary vis-a-vis the legislature. Aladi Krishnaswamy Iyer, however, felt that though due process in England meant due course of legal proceedings, it had acquired a different connotation with the US practices, particularly because the US Supreme Court had not been consistent in interpreting the Constitution, and its decisions have many a times been conflicting. Hence, he indicated his preference for procedure established by law as suggested by the drafting committee. In his rather detailed reply to the debate in the Constituent Assembly on draft Article 15 of the Constitution on 13th December 1948, Dr. Ambedkar said, "The question of due process raises in my judgment the question of the relationship between the legislature and the judiciary. In a federal constitution, it is always open to the judiciary to decide whether any particular law passed by the legislature is ultra vires or intra vires in reference to the powers of legislation which are granted by the Constitution to particular legislature. If the law made by the particular legislature exceeds the authority of the power given to it by the Constitution, such law would be ultra vires and invalid." That is the normal thing that happens in all federal constitutions. The question now raised by the introduction of the phrase due process is whether the judiciary should be given the additional power to question the laws made by the state on the ground that they violate certain fundamental principles. There are two views on this point. One view is that the legislature may be trusted not to make any law which would abrogate the fundamental rights of man, so to say, the fundamental rights which apply to every individual, and consequently, there is no danger arising from the introduction of the phrase due process. Another view is this, that it is not possible to trust the legislature. The legislature is likely to err, is likely to be led away by passion, by party prejudice, by party considerations, and the legislature may make a law which may abrogate what may be regarded as the fundamental principles which safeguard the individual rights of a citizen. We are therefore placed in two difficult propositions. One is to give the judiciary the authority to sit in judgment over the will of the legislature and to question the law made by the legislature on the ground that it is not a good law in consonance with fundamental principles. Is that a desirable principle? The second position is that the legislature ought to be trusted not to make bad laws. It is very difficult to come to any definite conclusion. There are dangers on both sides. For myself, I cannot altogether omit the possibility of a legislature packed by party men making laws which may abrogate or violate what we regard as certain fundamental principles affecting the life and liberty of an individual. At the same time, I do not see how 5 or 6 gentlemen sitting in a federal or Supreme Court examining laws made by the legislature and by dint of their own individual conscience or their bias or their prejudices be trusted to determine which law is good and which is bad. Though indicating his preference for the drafting committee's proposal, Dr. Ambedkar was non-committal about suitability of either due process or procedure established by law for India. It is significant, however, that even after Dr. Ambedkar made his dilemma clear, all the amendments were defeated and the draft Article 15 as proposed by the drafting committee was passed by the Constituent Assembly. The Constituent Assembly debate on Article 22. This issue of due process or the importance of procedural and substantive law was virtually reopened by the drafting committee when on 15 September 1949, Dr. Ambedkar introduced the draft Article 15A, which was finally incorporated in the Constitution of India as Article 22, after 2 days of intensive debate with a few amendments on 16 September 1949. Referring to the discomfort of the Constituent Assembly, including his own, and criticism in the public of the draft Article 15 for giving Parliament a carte blanche to make and provide for the arrest of any person under any circumstances as Parliament may think fit, he introduced Article 15A to provide for the substance of the law of due process. In this article, he put 2 provisions lifted from the CRPC through which he sought to incorporate 2 of the most fundamental principles which every civilized country follows as principles of international justice. The first 2 clauses of Article 15A, which added a caveat to detention of a person on any charge by providing him the right to be informed, consult a lawyer, and of being produced before the nearest magistrate within a period of 24 hours, were thus made sacrosanct and taken away from the authority of both Parliament and state legislatures. Clause 3B excluded enemy aliens or a person arrested under preventive detention from the protection provided in clauses 1 and 2. Clause 3 empowered Parliament to legislate on circumstances and period of preventive detention. The debate on this Article 2 was involved with members not only sticking to the sanctity of due process in order to rein in impeding Parliament tyranny, which they thought in a Parliament democracy would result in enhanced and skewed executive powers too. Traversing the entire field of debate all over again that was covered while discussing the draft Article 15, Dr. Bakshir Tekchand thought that Article 15A, with the proposed clause on preventive detention that had a weak protection for the accused and victims, created more problems, not only regarding personal liberty but also related to tyranny of the executive and legislatures. I submit this procedure is open to serious objection, and it is necessary that constitutional guarantee be provided so that legislatures of this country, provincial or central, are precluded from enacting legislation of this kind. It does not give any fundamental right to the people. In fact, it is a charter for denial of liberties. He proposed an amendment which sought to make it constitutional to seek explanation from the arrested accused to be placed before the advisory board provided in the draft article. Jaspat Roy Kapoor echoed similar sentiments, that the entire issue of the period of detention was being left to the good sense of Parliament, whereas as a matter of fact, you, referring to Dr. Ambedkar, are suggesting the extent to which the legislature can freely go to impose limitations on personal liberty. So far as detainees are concerned, they are given no protection in this chapter, and I submit that this is very hard and strikes at the very root of fundamental rights and personal liberty. Briefly speaking, the members virtually went along with the drafting committee, commending it and suggesting minor suggestions on the first couple of clauses which provided constitutional guarantee to the two sections of the CRPC but had objections, some of them very serious, to the clauses relating to preventive detention, which they thought gave undue powers to the legislature and the executive, compromising on the spirit of due process. Various suggested amendments were aimed at blunting the edge of detention in one way or the other. However, a strong defense of the proposed article came from Aladi Krishna Swami Iyer, who felt that, I might mention that the main reason why due process has been omitted was that if the expression remained here, it will prevent the state from having any detention laws, any deportation laws, and even any laws relating to labor regulation. Labor is essentially a problem relating to persons, and I might mention in the United States Supreme Court, in the days when the conservative regime dominated the USA politics, enactments restricting the hours of labor constituted a violation of the due process of law. An American would have been employed for 5 hours, 10 hours or 20 hours and make a slave of himself, and yet it was held to be interfering with due process of law if there were restrictions on the hours of labor, until the United States Supreme Court put a different construction in a later decision. A detailed reading of the debates on Article 15 and 15A brings out one point very clearly, that while the drafting committee led by Dr. Ambedkar had, as he stated at the closing of discussion on Article 15, had no particular preference between procedure established by law and due process, they were leaning towards parliamentary supremacy in lawmaking, with sufficient constitutional and judicial safeguards for personal liberty, as against judicial supremacy in determining whether every law was in accordance with due process or not. To conclude, we can say that the Constituent Assembly debates in India do not convey a clear indication of the preference to either of the two concepts of due process or procedure established by law. While many members favored the concept of due process, the others favored the concept of procedure established by law. Article 15, which now is Article 21 of the Constitution, has been adopted as was proposed by the drafting committee without any amendments, and the draft Article 15A, now Article 22 of the Indian Constitution, was adopted by the committee after a few amendments. Dr. Ambedkar leaned towards procedure established by law, although providing certain kinds of specific limitations on the power of the Parliament to exercise their right, legislative right. However, judicial review, in his opinion, was limited and was to be exercised only as a guardian of the Indian Constitution and not in any other manner.